Hey guys, so are you an executor or an administrator to a probate in Middle Georgia? Well, if you are, then you may have a few questions about how the probate process goes in the state of Georgia. Well, in this video series, we're going to cover all the taboo questions that nobody wants to ask about how the probate process works in Georgia, particularly in Houston County and Pulaski County. So let's get started. Hey guys, I'm Chris, your real estate problem solver and probate specialist for Middle Georgia. I've been an investor and an agent for over 20 years in the Middle Georgia area, so I know the real estate market. And as an investor, I buy a lot of probate houses, so I know a little bit about the probate process for the state of Georgia, particularly Bibb County, Houston County, and Pulaski County. So in this particular video of a 4-part series, we're going to step into Pulaski County Courthouse and we're going to talk to the probate judge, Judge Jones, and we're going to ask the probate judge exactly what kind of things that he does in the probate process, what kind of things you need to bring to him for the probate process, and also where you're going to go from here. So let's go on in and talk to Judge Jones. So in this part, we're at the probate judge's office. This is our probate judge, Jeff Jones. So Jeff, just tell me, I lost my mom and I'm doing her probate estate. So where in the probate process do you come in?
I come in after a petition has been filled out, either by an attorney or you can do it pro se, which means do it on your own. It's a little bit, if you're not really sure about what you're doing or what type of probate you need, you probably would need to see an attorney. In some cases, you don't need to probate at all. It's just according to what kind of property you've got, how the deed is written, and what other kind of personal property or whatever the state might have. But you actually come to see me after you get a petition filled out and you file that petition in the court.
Okay, so do they file it here at the probate office?
Right. If the deceased is a resident of Pulaski County, they will file it in the office of Pulaski County Probate Court.
Okay, so it is in the residence that they just died in, or the residence that they lived?
It's their residence or any county that they owned property, real property and land or home, something like that.
Okay, so if, say, I died and I have property in Bibb County, Houston County, Pulaski County, we would have to file a petition in all three?
No, you can choose one county.
Okay.
Now, most do it in the county of residence or where the deceased lived. That's where 99% of them are done. But you do have that option to file in a county that you own real property in.
Okay. So you said that it depends on the type of filing. What are a couple of the most common filings?
Well, the two most common is a probate will in solemn form. That's when actually, you have a will, the deceased had a will, or a letters of administration where there was no will. There's derivatives of that, a temporary administrator, common form probate. That's why I would say if you're not sure what all you got, you need to see an attorney to know exactly what you need to file that suits your particular aspects of that estate.
Okay. So since the probate with a will is pretty cut and dried, let's say I don't have a will. What kind of paperwork would I need to bring to you?
If you don't have a will, you need a petition petition for letters of administration. That covers when you don't have a will. At that point, you need your petition and, of course, signatures of all the heirs. And
what exactly does that do?
At that point, everybody that is involved in the estate has signed off, which is blood relatives. And there's a breakdown of that line of inheritance. At that point, once you get all that done and you file it here at the court, then we decide, or through the petition, we know if an ad needs to be run in the paper before or after proceedings, if somebody's got to be served, if you can't get a signature of heir at law. Once all that's done and the time's run, then we sign the order, I sign the order, and we issue letters of administration, which then gives that person the authority to act on behalf of the estate.
Okay, so to clarify, the letters of administration is giving permission for one person to handle the estate.
Right. One or two, sometimes it's multiple, but just according to what the family agrees to.
Okay. Okay, that makes sense. All right, so let's say that they got their letters of administration, they executed, they got your ratification of their assignment. So, is there anything else that they would need to do with your office?
No, nothing. The estate has to be open for 180 days. So they have 180 days to complete their, at least 180 days. They have to keep it open for 180 days. At that point, if everything's done, they have the option of filing to be dismissed from the estate as the administrator or executor. And that means everything's done. There's nothing left to do. We're going to close the estate. Nothing can be filed against it at that point. So you have 180 days you keep the estate open, at least, a minimum. And then you're through with us. You're through with the estate.
Okay. So the 180 days is allowing creditors and debtors to come in and lay a claim to the estate for anything that's owed.
That's right.
Okay. Now, what about the real estate part of it, real property? Is there any way that a house could be sold during the probate process?
No. You can't sell any, you can't dispense with any assets of the estate until after an executor or an administrator has been named and taken their oath and letters issued.
Okay.
Prior to that point, you can't convey any property, personal or real.
Okay. So, but once an administrator or an executor has been assigned, can the property that say they're running out of money and they need to pay bills, can they go ahead and sell any real property?
That's do whatever you got to do to pay the bills, pay the debts first.
Okay. And then once that's done, then of course the proceeds go back to the estate to pay the bills off.
That's right.
Okay.
And once all the debts are paid, then it gets distributed out to how the will, or as in the case of administration, the state sets out how that money will be split up.
All right. So once that's done, at what point are they finished with your office?
Once they get the letters of dismission, they're through with us.
And that would be through an attorney, or
either way, yeah. It's kind of like probate and will. Do you need to do it or do you not need to do it? But I always advise anybody ask me, you need to be dismissed and not leave that estate hanging open.
So is there any paperwork that they need to bring to the office, or other than the petition to open the estate or open the probate?
No, just the petition itself is all we need.
Okay, and they'll decide that with the help of an attorney, or
right.
They'll just...
That's what I suggest.
Okay.
Just go see an attorney.
Okay. So is there anything after in the process, or is there anything beyond that point once the estate is closed?
But once that will's probated and everything's completed and it's dismissed, or once it's probated up until the dismission comes, the probate court's done with the estate.
So there wouldn't be any other processes anywhere else or down the line that you know? Okay.
Not unless there was problems within the estate. We do have those where accountings aren't filed and heirs aren't given accountings of what's going on in the estate. We do have those occasionally, but for the most part, once the letters are issued, we're out of it.
Okay. All right. Well, they're good. Well, I appreciate your time. Okay, so I hope Judge Jones helped you understand the probate process a little better. When you go to the probate court, you're going to have all your paperwork ready, or you'll at least have the right answers when they ask you the questions, what kind of paperwork do you need, and the situation with the probate process for your family. So next, now that we've talked to the probate judge and you understand a little bit more about the court system, now only thing left to do is finish the probate for the courts, file everything, and get it closed out, which includes getting the final tax return done for the estate. So next, we are going to go to an accountant, and we're going to talk to them about how to file the final tax returns for the estate for the probate process to be completed out. Now, if you have any questions, reach out to me. If you have any need for any probate services like cleanup of the property, selling or leasing of the real property of the estate, or if you need to do an estate sale, or if you need help finding an accountant for the taxes, probate attorney to help you with the probate process, reach out to me. My information is in the description below, and let's go to the next video.